You're watching Newsfeed AM. Let's pick up on this discussion now. Opposition parties are planning a court action against the Office of the Public Protector after she found that President Cyril Ramaphosa did not violate the Executive Members Ethics Act in the Phala Phala farm scandal. Joining us now is the Acting Public Protector, Adv Gcaleka, to respond to some of what her reports have contained. Adv Gcaleka, thank you very much for your time. Let's go straight into the heart of the matter. A number of political parties, they're saying that your final report on the Phala Phala investigation exposes your bias to shield President Cyril Ramaphosa from accounting for wrongdoing, and that's why they plan to challenge it in court. Are you confident that this report is going to withstand legal scrutiny?
Good morning, Xoli, and good morning to the viewers. This report, as you might have seen it and gone through it, there's a lot of application of the law to the facts of the matter, to the evidence that has been presented before us as the Office of the Public Protector. This report has been well thought, having considered the entire process and procedure that is required for us to produce a final formal report in these terms. This report has been processed, even went through vigorous quality assurance within the institution. We are of the view as the institution that we did the best we could in terms of assessing, applying our methodology, applying the jurisprudence that has been created through law, but as well as through our legislation, through the Executive Code and the Public Protector Act, which is our legislation through which we have worked in this manner. At this point, I am factus officio. It is up to the court, should the matter be taken on review. The law is really a matter of interpretation. Hence, you've got applicants, defendants in every matter, and you found that both have got different case law and other supporting authority for the arguments that they are making.
Yeah.
However, I am confident that this is a matter where the Office of the Public Protector would not be found to have been biased or dealt with the matter in a manner that is unbecoming. The court might arrive at a different decision. That is really up to the court, but we are confident that we have done the best we could in line with the law.
Well, on the face of it, Acting Public Protector, let's test then just how well thought through, to use your words, this report was compiled. Is there any doubt that money exchanged hands at the Phala Phala farm between the buyer and the seller?
We have been furnished with a receipt of sale in this particular matter. So as far as our investigation is concerned and the evidence before us, which is the evidence of the workers at the farm, but as well as the receipt which confirms the sale in our possession, therefore there is no doubt in respect of the sale. Okay.
Did Mr. Dumisani Ndlovu, this is an employee at the farm, receive an instruction from his employer, that's President Cyril Ramaphosa, upon receipt of this sum of $580,000 US?
We have no evidence to that effect.
Is it not contained in your report that an instruction was issued that this sale should not be concluded until Mr. Ramaphosa returns from holiday on or about January of 2020? Is that not part of your report?
No, that is not in our report. Not at all.
So what information did Mr. Dumisani Ndlovu tell you?
In respect of Mr. Ndlovu, he informed us of a sale that took place. He insisted that the sale was in the absence of the president and that the president was not involved in the sale. it is in respect of the foreign currency, the money involved, which he had discussed with the president, but that is after the sale had taken place. So there was no discussion regarding the actual sale.
If there was a discussion around the foreign currency post the sale, the nature of that discussion, are you able to level with us as to what was discussed between Mr. Ndlovu and the president?
The discussion really was way after the sale had taken place, you know, that there is money at the farm regarding a sale that had taken place, because Mr. Ndlovu was temporarily in charge as Mr. Von Vela, who is actually the farm manager at the time, was on leave. So at all material conditions, the discussion held did not involve the peculiar information regarding a sale that had taken place, but it was in respect of the money that was there, which Mr. Ndlovu had to leave because he was going on leave. And the president, after being at the farm, informed him that he was going on holiday and that it would be attended to upon his return from holiday.
That's a discussion, acting public protector, between the president and Mr. Ndlovu, who was in charge of the farm at the time. So how is it that you are insistent that the president made no particular instruction around how the money would be dealt with? Because otherwise, then it begs the question, what money was the president aware of, and where would it have come?
No, the discussion was not around the sale.
Right.
The sale had already taken place. Now it was around the money that was on the premises of the farm, but not the sale.
Was the discussion about where or how this money should be handled? Because clearly there was.
No, there was, in accordance with the evidence before us, there was no intimate discussion regarding how the money should be handled. It was merely that the president is going away on holiday, and that how the money would then be dealt with, he would then engage with that upon his return on holiday. And that is as far as evidence that is before us.
That, in my interpretation, just based on what you have just told me, Advocate Gcaleka, that is a discussion post the sale as to what to do with the money. Does that not prove to you that the president was not a mere bystander here, but rather a participant in game farming?
Only if you look at our report, we actually make an acknowledgement that the president was actually involved. However, we do not have sufficient evidence in respect of his involvement to make a conclusion that his conduct amounted to paid work. So we actually make that acknowledgement in the report. And that acknowledgement is on the basis, firstly, of this discussion, which, by the way, is not a discussion on the sale, but it's on the discussion that Mr. Ndlovu is going to have the money left on the farm when he goes away on holiday. And the president agrees and then says he'll then attend to it upon his return because he's also going on holiday. So that, for us, really cannot amount to say that the president was involved in paid work. But as I say, we did acknowledge that he does have involvement in the farm.
Did the president admit to you during your investigations that he's the one who identifies potential buyers of buffalo on his farm?
Well, his admission wasn't that he identifies potential buyers, but there was a conversation between him and the farm managers that there were buyers who were interested in the game, but not that he had identified those particular buyers. And if you read further in the report, you would see that there was actually a safari, which is a company that was doing marketing for the farm and the game.
Yeah. So it would appear here, Advocate Gcaleka, that we are dealing with what you would call a play on words, if you like, because there's no denying that the president is involved in the operations at Phala Phala. There's also no denying that at times, I guess, he does identify potential buyers. So how do you come to the narrow conclusion? And I call it narrow deliberately because you are saying the operative word here is paid work. Are you able to prove, for example, or you take it from the president's word that yes, he has involvement on the farm, but he actually does not take money as a form of income?
Firstly, let me say there is no agreement there that there is an active day-to-day involvement of the president. And as we acknowledge in our report, yes, he is involved, but there's insufficient evidence to conclude that that is day-to-day involvement in the operations, because there is a farm manager and there's also employees in the farm. And there is also evidence that the president is not always at the farm. Therefore, we are unable to reach the conclusion that the president is involved in the day-to-day running of the farm, or rather the day-to-day operations of the farm. And further on the issue of the president receiving paid work, we need to look at the nature of the business. This is a close corporation. Yes, the president is a member, he's a director in this close corporation, and therefore there is members' interest in this respect. Now, you've got to differentiate whether the president is a worker in the farm or he bears financial interest in the farm. And there's a distinction between the two. And in line with our investigations and having looked at the definitions, we've arrived at the decision that he bears financial interest in the farm. And therefore, there is no evidence at our disposal to say that he actually receives paid work. Because if we would have to come to that conclusion, we would have to prove that the president is involved at the day-to-day operations of the farm.
You would have to prove one thing,
time in and time out. And further that the president works at the farm. On the issue of tracing the monies, first and foremost, the Office of the Public Protector is mandated in line with the Public Protector Act to actually deal with monies of public funds. Now, when it comes to private funds, we need to trade very carefully. We need to at least have prima facie information on the basis of which we would draw the suspicion that we need to trace the monies. You are aware of the CR17 matter where the Office of the Public Protector was taken to court, and we actually lost that particular matter. And therefore, it is important for us to learn from the jurisprudence and ensure that we work in line with that. So in tracing of the monies, firstly, we would have to prove that he works at the farm. And in our view, that would then be able to give us some form of a basis on which we would then have to trace the pay for the work that he is performing at the farm. And therefore, we were unable to prove that he works at the farm.
Advocate Gcaleka, you and I have agreed that the president was aware of the money of the sale of this game. Did at any point your team or yourself put a question to the president as to why this money was kept in a sofa at the farm?
Well, yes, we did. But the president was unaware that the money was kept at the cushions of the couch at the farm. So when the discussion took place between himself and Ndlovu, he was not informed where the money was being kept, but he was aware that there was money at the farm of a sale that had taken place, but there was no discussion prior and immediately after the sale had taken place that a certain sale had taken place.
Does that, for you, therefore, not raise suspicion? This is foreign currency that is kept at the property, and on top of it, it is kept in a sofa. Does that not raise suspicion that perhaps there is something much more that is untoward here, and therefore we actually ought to start money trails or investigating money trails?
Untoward in respect of what, Xoli? We need to stick to our mandate. Our mandate really is to deal with issues that are under the Public Protector Act and the Executive Members Act and the Code. Now, in respect of how we dealt with this, we said, what are the facts before us? What's the evidence before us? Within whose jurisdiction does this fall? We identified that there might be issues of tax related in this manner. We approached the South African Revenue Services. There are issues of foreign exchange here. As you rightfully say, there is foreign currency. Now, who is the primary institution or primary authority responsible in this regard? We approached the South African Reserve Bank in this matter. There is a housebreaking with an intent to steal and theft that took place here. Probably the suspicion on more of this. Is it our jurisdiction? Whose jurisdiction is this? We approached the DPCI, the Hawks, in respect of this matter, and we found that they are investigating the issues that actually falls within their jurisdiction. And what is it for the Public Protector to do, taking into consideration the judgments that are before us, is for us, as you describe it, narrow. But that narrow for us means that we need to look into the factors that fall within our jurisdiction and actually do not go overboard and make conclusions that fall within jurisdictions of other institutions.
Let me pose this question to you then, and you enlighten me as to whether this falls within your jurisdiction. The fact that the buyer, this Mr. Mustafa Hazim, has to this day, at least to our knowledge, not received the delivery of the cattle. Was that question put to the President, first and foremost?
Yes. Well, there's a process in respect of the sale of this type of game, because after the sale has taken place, considering that this is extraterritorial, it's outside of the South African jurisdiction. So there are certain tests that needs to take place, etc., before the game can actually be transported or be in the receipt of the buyer. So considering that particular process, it made sense from at the time. But now the complications come that now the money has been stolen. You know, there is no money before and what has since taken place. So that for us necessarily doesn't mean that it is an issue for us to investigate a sale between two private parties, because our involvement, I wish to repeat, is in state affairs. And as far as the President is concerned, is his conduct in terms of EMEA on whether he did paid work and whether there was a conflict of interest between that work that he does and his responsibilities as the head of state.
Advocate Gcaleka, we have dealt with matters that raise reasonable suspicion. So as we sit here today, you can't tell me that there has been delivery of the cattle, in part because of what you are explaining, that now money has been stolen. But that assumes that the entire amount has been stolen. No, it doesn't appear that it was the entire amount that was stolen. So let's move to the second question. If there has been no delivery of cattle, yes, money is received. How do you confidently use the word sale in this transaction? Because that assumes that this was a legitimate transaction. Was it?
That is not a matter for our investigation, Xoli. Before us, we have what satisfies that there was at least a receipt. Somebody arrived at the farm, because we even traced whether Mr. Hazim indeed was within the country during that particular period through the Department of Home Affairs, and we established that indeed he was in South Africa during that period, and through the receipt we established that indeed he did pay for game at the at the Phala Phala farm, which was to be delivered to him after particular processes had taken place. Now, whether this was money that came in, whether it is fraudulent, whether it is a particular sale and so forth, it is my respectful submission that that is a matter for this DPCI to be investigating, and they are investigating that particular aspect, because within our investigations we have interacted with the different public bodies conducting investigations. So it is very important that we allow them to conclude those investigations, because we have made no finding in respect of those particular matters. So the President has not been cleared regarding whether there was anything untoward in respect of this particular transaction. But in respect of what satisfies what we had to investigate in terms of EMEA and what we had before us, we have then concluded in that respect.
All right, let's pause there, Advocate Gcaleka. When we return, we conclude discussions around the Phala Phala matter and look at other reports. You're watching Newsfeed AM. If you're just joining us, we are in the middle of a conversation with the acting Public Protector, Advocate Xoli Gcaleka, and we are discussing a number of reports, and in particular, the one that's dominated discussion so far is the Phala Phala report. So, Advocate, let's conclude on this Phala Phala matter. We've gone through a lot of ground, and at least based on what I've assessed, they're just things that are glaring that I think you've decidedly chosen to overlook. But let's conclude, therefore. And we conclude in this way. When politicians accuse you now of a whitewash in order to put yourself in pole position for the top job at the office that you hold, do you think it'll be easy to prove them wrong under these circumstances of what we have just discussed?
Firstly, I beg to differ that there are issues that we've overlooked. If you really read into our report, we make even certain observations and we make certain remarks regarding what had taken place in Phala Phala. And we also state that the basis on which this allegation came before us was on an affidavit that's based on hearsay evidence, whose sources were not revealed to us and whose sources we could not establish. Therefore, we went as far as we could in line with our investigation techniques and what we could find. And part of what we could find actually was that some of the information in this report could not be verified as information at Phala Phala. For instance, the video clips and the photograph, etc. Therefore, it is really not a straightforward matter as it is. But also, we were guided by our mandate. We were guided by the case law before us. I mean, we've got the GEMS matter that says that the Public Protector needs to allow institutions which are primarily vested with certain investigations to conclude those investigations before running a parallel process, because you also do not want to have conflicting decisions. And whereas that primary institution would not have been granted the opportunity to finalize their investigation. We've taken the lead from the courts. But also we've got judgments, and which has been confirmed recently in the Mabuyane matter, where the Public Protector has been found to overstep its mandate into matters that have a criminal nature, and which is the mandate of the Hawks and the NPA. And we've heeded the call, because the CR17 also says how we have overstretched our mandate and went into private funds. And issues of investigating private funds, it's not the mandate of the Office of the Public Protector. Ours is very clear from the Constitution, is state affairs. In our Act, it is funds within the state. And therefore, we have worked within that particular scope. I am confident that should this matter go to court, the court would not find that we have been biased. The court might find a different interpretation of the law, but that is really a matter of interpretation of statutes, but not a matter of bias. Therefore, I am not worried that any malice would be found in the manner in which this report has been investigated. If you notice, even from the media briefing we had, the investigators, the head of legal services, the entire team at Public Protector South Africa knows this matter in and out, because they interacted with this matter even before I got involved in this matter. I get involved at a later stage, at a quality assurance stage, where I need to satisfy myself that the work done is in line with the facts before us, the evidence, the law before us, and properly provide that assessment. And that is the process and procedure that took place in this matter.
I have to put this question to you. Did you and your team contemplate giving a final report that does not give conclusive findings, such as we exonerate the president from wrongdoing? In other words, did you contemplate giving a report that leaves the public with an open-ended question, given that there are institutions, such as you've mentioned, the Reserve Bank that's still investigating, the Hawks that are still investigating? Should those come back and say there was fault here, particularly on the part of the president, therefore we do find guilt or wrongdoing? The reason I'm asking you this is because it has a bearing on your reputation.
Should that happen, it will obviously, for instance, on part of the members of parliament or any other member who is entitled to do so in respect of the Executive Members Act, they can then lodge another complaint with us, or we can even trigger an investigation in terms of the Public Protector Act. But at this stage, it's really areas that we cannot touch on, because those institutions are still interacting with the matter and the facts in line with their particular mandates. Hence, we did not deal with those. We contemplated that we've got a mandate within which we function, and we've got working relations with other institutions which have a primary mandate in respect of certain aspects in this particular matter, and therefore we need to act within our mandate and not find ourselves in the position in which we have found ourselves before.
Let's then bring other reports that you've released. There's a report on a man who was unhappy with the Department of Trade and Industry. That case was lodged with your office in 2019. They only received the outcome last week, same as a student who lodged a complaint against the University of Cape Town, 2019 as well. Why does it take so long for the Public Protector Office to finalize reports?
It's twofold. Firstly, we are under-resourced and we are understaffed. Investigators in the Office of the Public Protector are sitting with an average of files which far exceeds the international standards in respect of matters that they should be dealing with. Therefore, that contributes. Secondly, the state takes time to respond to allegations, and therefore we need to ensure that due process takes place to ensure that we are able to follow process and ending up with a subpoena and so forth in respect of our hard powers. But also what we've established within the Office of the Public Protector, which I really need to come up front with, is that the manner in which we've been assessing our matters is not a manner in which an institution with the volume and complexity of matters should be doing that. So there are some matters that we take up that we should not be taking up because of our assessment processes. Matters were being assessed in the Office of the Public Protector by the most junior of people. And by the time the matter is in the hands of the experienced and senior people, they either at that point only find that probably we don't have jurisdiction in this matter, we haven't proven this in this matter, there's particular gaps in this matter, and the investigation almost in a technical sense needs to start all over again. But we have now turned that around. The assessment is done by the most senior of people whom are the executives, and they are able to ventilate and properly assess what kind of a matter is this, what is required, should we do a preliminary investigation, who is the best suited person or persons, or whether it's a team that needs to be put together in order to speedily or finalize the matter in time. But we are also busy with a process where we are really doing a cleanup of our matters, and also the case management system, which is going to assist us really to resolve matters much better. So it is a multi-pronged issues that causes matters not to be finalized speedily.
I remember a time when the few times that we've interacted, yes, sitting across the table as we are doing now, where you were absolutely confident, in fact, at the risk of using this word, that it was almost showboating, that you resolve matters with speed, and you even went to Parliament to demonstrate just how quickly matters are finalized when you were at the helm. This was at the time that the suspended Public Protector had taken leave. 4 years is a very long time, Advocate Gcaleka. The question I'm coming to is, how do you give assurance to members of the public that your office does not just prioritize political cases or cases with famous faces attached to it, that those cases are prioritized? Because this office, its establishment is to satisfy the members of the public that come to your office to complain.
Indeed, I mean, with just over a year of acting, we have finalized the Phala Phala matter within a year. And if you look at similar matters involving high-profile figures, for instance, I'm going to take the matter of the former Deputy President, the Mabuza matter, of the purchase of cars. It took the office 5 years to finalize. If you look at other EMEA matters, when I came in, they had been on the roll for about 65 months, 45 months. We have finalized those matters. If you look at the matters that you have just referred to, it was in 2019, and I was not even at the Office of the Public Protector then. So we have actually made strides on a number of matters. As we sit for this quarter, we have finalized over 1,400 matters. Yeah. So which actually shows that there is a vigorous process and a project that's being managed to deal with the backlog.
Let me put this final question to you, and I'm sure it'll be an easy one. Are you interested in this job? We know that the term of Advocate Busisiwe Mkhwebane is here. The job is already being advertised. Have you applied?
I have not applied, but I'm aware that there are organizations that are nominating me for the job. They've approached me, and I have agreed.
So you want the job?
Should I be selected for the job, I would do the job.
Thank you very much for your time.
Thank you.
Advocate Xoli Gcaleka is the acting Public Protector, and that's about all that we have time for today.